example, is the whole issue of statement of use. In a horrendously bad, sorry, in a horrendously bad decision by the High Court of Delhi, which neither was sound in law and on totally incorrect implementation of law, the Delhi High Court made a comment that the Controller General and the Registrar of Trademarks are two different persons when the Act itself says that they are the same, and that the Controller cannot dictate directions to the Registrar of Trademarks. That was the actual order of the Delhi High Court. Now, as it stands, an important aspect when filing trademark applications in India is the requirement of use. You have to be absolutely particular on the dot for use. The actual you can file applications in India which are proposed to be used, but you need to have you need to put a date of use in your application which is accurate and which can be proved. If that date of use is wrong, you can't amend the date of use under absolutely normal circumstances. You can't amend it, and if it goes into litigation, either in opposition or in revocations or infringement actions, the right itself can be in jeopardy. There were a couple of other issues that happened throughout the year, and I would like to share those issues with you. Increasingly in India, use of the trademark outside of India, and it doesn't matter whether the mark was not used in India, was just used on a website, or was not even used on a website. For example, if it's a pharmaceutical trademark, increasingly in the year 2014, and finally, if we speak of the Max Trade judgment, the judgment of Sher Khan versus Royal Bank of Scotland. In this particular case, it went on to say that if there is a mark which is outside India, with some amount of use, no person can use that mark in India. No person can adopt that mark, and if that mark is used, that mark will be injuncted. So this is a strong departure for most other jurisdictions worldwide, where trademarks are supposed to be territorial, but in India, this now extends to the use of the trademark by an Indian entity in India. This is something we must advise and we must tell all our clients and stakeholders. The year opened with Justice Manmohan Singh opening the innings with the Pranic healing case. In the Pranic healing case, it was held, although the mark was registered, the mark was considered to be generic, and an interim injunction against the use of that mark was not granted. Finally, the whole issue was that whether the trademark, whether a high court, for example, can deal with validity of a trademark. As you know, after the IPAB was formed, validity of trademarks can only be dealt with by the Intellectual Property Appellate Board and cannot be dealt with by the High Court or a district court during litigation. The High Court of Bombay, finally it was left to the High Court of Bombay, which made it very clear that unless it is unconscionable, unless the registration is unconscionable, it is against the conscience of the court, and there is some fraud was conducted at the time of opening, at the time of getting this mark registered, the registration stands and nobody can use this particular trademark. So therefore, these are two diametrically opposite views. One was the Bombay High Court, one by the by Justice Manmohan Singh in the pranic healing case. We had two different findings. The Bombay High Court case was in the case of Gluco, GLUCO, for biscuits, which is probably an iconic biscuit brand in India. As far as the other few trademark cases of interest was, for example, Sab Miller was able to succeed in getting exclusive ownership rights for the trademark 5000. You know Hayward's 5000, the word 5000 for beer. That was so you could have exclusive rights for a numeral. And one more case, or one more series of cases, or a series of cases in the Bombay High Court, in the Delhi High Court, all decided that jurisdiction is now, so that anybody can sue on the basis of web presence. If you have a web presence, for example, if somebody is using a mark on the website, or if the plaintiff is using the trademark. In the WWE case, if the plaintiff has e-commerce business in India, then he can sue for example, the Delhi High Court. So the Delhi High Court has gone to the extent in saying that you don't need to have presence. The plaintiff doesn't need to have presence. The defendant doesn't need to have presence. If the plaintiff has e-commerce activity in the territory, they can sue. In this case, the plaintiff WWE was international. It wanted to sue in Delhi because Delhi was the court of convenience, and it sued a person in Bombay who was running an activity with no activity in the Delhi High Court. Yet the court said, we will exercise jurisdiction. So these are the few cases as far as trademarks are concerned. When it comes to let's take a few of the patent cases that happened in 2014. I'll echo a few of the some of the cases that Archana spoke of. This whole aspect of patent trolling became an important issue in the United States in 2014. Following this, there was a case of the Delhi High Court, and the case is against, it's called Sandeep Jaitka versus Mukesh Mittal, where the plaintiff was not using ostensibly he was not using the invention in India, or was not using the invention at all, not just India, he was not using the invention at all. When he sued, an injunction was not granted. So this aspect of non-performing entities has now been codified, has now got judicial recognition in this particular case. There were two treaties cases which ran into almost 200 pages in Chennai and 143 pages in Delhi, in an interim injunction patent matter. The Chennai case was the judgment of Justice Ramasubramaniam in the beginning of 2014, and the case in Delhi was a case running into 143 pages. Justice Manmohan Singh's judgment in Novartis versus Cipla, the Onbreeze case, or in Indaketerol case, which is now under appeal. Both these cases are landmark cases on what is novelty, what is inventive step, the whole details of how patent application should be dealt with, how evidence should be dealt with. And coming to evidence, there were two major cases, one of the Calcutta High Court and one of the Delhi High Court, which dealt with who should be and how should an expert, or who should be an expert witness, and the criteria of these expert witnesses who lead evidence were detailed in these two cases. One in the Delhi High Court, and in this case it was their qualifications was equated to that of a scientific advisor that were noted, that was noted in the Indian Patent Act, Section 115, and you had also the expert witness under the Evidence Act of the Section 45 of the Evidence Act, where your expert witness must have must have that kind of. I'll just wrap it up in 5 minutes. Will have those rights to give evidence, and finally the Calcutta High Court says, which is going to revolutionize IPAB matters, where it says that if there is an expert witness that is led before the IPAB, either side is now entitled to cross-examine. There were, of course, in the end of December, there were 2 leading cases which I would urge all of you to try to get hold of. This was the Micromax case. The Micromax case versus OnePlus. The Micromax case versus OnePlus, which deals with the Android platform and the Cyanogen platform on either end. On the 16th of December, OnePlus was injuncted from use of that particular platform, the platform and that particular and the patent rights relating to it. And on the 26th of December, that particular injunction was vacated. Now, what is interesting in that injunction is that the entire the judgment came very strongly and criticized the Delhi High Court for granting what are called ex parte injunctions at the drop of a hat. Why Delhi High Court is preferred as a suit for IP activities? Because you get interim injunctions there at the drop of a hat, and therefore the divisional bench of the Delhi High Court has now come down with a strong edict that the single judge who's granting these kind of ex parte injunctions must show that why even 1 day's delay. 1 day's delay would be fatal to the case of the plaintiff. And coming to a last issue, I mean, a lot is said about the Alloy Wobbins case. The negative fallout from that case is, which Archana did mention, but I would want you to urge, and I believe this, as soon as possible, somehow that aspect is clarified to the Supreme Court, the faster, because I'm not sure that the parties are going to do that. And it's up to the IP community to do that. The Supreme Court, by a stroke of a pen, has deducted 1 year's patent right of a patent holder. I think that is something that the Supreme Court has said that within 1 year of your grant of a patent, you can't sue, which means you get a patent after 7 years or 8 years sometimes. Therefore, now that 7 or 8 years you are waiting for your patent to be granted, 1 more year has gone, and I think it is a regretful decision. It's not to that extent. The other issues are fine, clarification, but this is an extremely regretful decision, which I believe it was the responsibility of all litigators to point this out to the Supreme Court, that why they went wrong. Right, guys? Thank you. I think since time is running out, I'd be glad to take any questions at a later point of time. But I'd like our guest speakers from overseas to come and speak to you. Thank you.